You were hired by defense counsel.
That is correct. I was retained by defense counsel.
You were hired to provide your expert opinion on the investigation of Ms. Bancroft.
Yes, that is correct. Not just necessarily of Ms. Bancroft, but of the entirety of Detective Keenan's investigation, beginning in 2013 at the behest of his police chief, Francis Kimball, up until the day of the arrests of Ava Bancroft and Chase Covington.
Thank you for that. Mr. Lorien, Detective Keenan, he was the main focus of your investigation, correct?
Both Detective Keenan and the MSPD were my main focuses. However, specifically relating to the investigation that took place against Ms. Ava Bancroft, my main focus was on evaluating the techniques used by Detective Keenan.
So your main focus was on evaluating techniques used by Officer Keenan, yet you don't recognize Officer Keenan today, do you?
I do not recognize him today. However, I am very much aware of who Detective Keenan is and what he did during this investigation.
Your Honor, permission to strike the latter part of that witness's testimony is not responsive.
I mean, I think I'm going to deny that. He was simply stating why he would not recognize Officer Keenan, so that's denied.
Now, Mr. Lorien, a yes or no to my question, please. You failed to interview Officer Keenan, correct?
I did not fail to interview Officer Keenan. It was actually a strategic decision that I made not to interview Detective Keenan. Typically, in order to launch an unbiased investigation into whether or not proper conduct was used, it is very standard for professionals like myself to solely base our conclusions on objective facts and objective documentation that we receive. This was simply a strategy to remain as unbiased and accurate as I could.
Well, you didn't interview his informant, Corey Hyde.
No, for very much the same reason I did not decide to interview Mr. Hyde.
You didn't interview your own client, Miss Avery Bancroft.
I did not either, for very much the same reason.
So, Mr. Lorien, to be clear for the members of the jury, you haven't even spoken to anyone relevant to today's case, have you?
That is not true, counsel. I've spoken in great length with defensive counsel as well as with the other auditors at my department in order to determine what the best course of action would be in investigating Detective Keenan's use of investigative techniques in today's case. And I was able to reach all of my conclusions to the highest degree of certainty possible.
Well, let's just be clear for the members of the jury. You haven't interviewed you've never spoken to a single witness in today's trial, have you?
I do not believe so, no.
And you haven't spoken to anyone who's an employee at the Black Bear Casino?
No, I have not.
You never spoke to Mr. Covington?
I did not.
Mr. Lorien, you spoke on Officer Keenan's undercover training on direct examination. You're familiar with Officer Keenan's affidavit, aren't you?
Yes, I am, as that was one of the materials which I reviewed.
You are aware that Officer Keenan's real name is not Mickey Keenan.
I am not aware as to what his real name is, but based on my experience with the FBI, it is standard for investigative officers working in undercover operations to use an alias. That is acceptable.
So you're not aware that Officer Keenan's real name isn't Mickey Keenan?
I'm sorry, counsel?
Are you saying that you're not aware that Officer Keenan's real name is not Mickey Keenan?
His affidavit was redacted, and it was stated very specifically that Mickey Keenan was an alias, so I am aware that that is not his real name.
Dr. Lorien, you are aware that Officer Keenan is operating on another investigation right now, correct?
Yes, I am. However, I have not gone into in-depth research as to what that investigation entails. I was simply hired to analyze this investigation into Ms. Ava Bancroft.
Mr. Lorien, as an expert in your field, you are aware that certain information regarding undercover officers can be classified.
That is certainly true. However, I am also aware in my field that information regarding training, information regarding techniques can be obtained with a Freedom of Information Act request. When I worked at the FBI for 25 years, we were very certain that even when we used an alias, we still used that alias on certification documents so that we could provide defense counsel and prosecution counsels in our various cases with training certification, even if that training certification had to have an alias on it instead of the real name.
Thank you for that, Mr. Lorien. Now, you've been in trial before, haven't you?
Yes, I have.
You've testified in trial before.
I have.
You know what cross-examination is.
I'm familiar with cross-examination.
I'm just asking for a yes or no. Now, Dr. Lorien, since that is true, that information regarding undercover officers can be classified, it's possible that Officer Keenan's documentation is classified.
I do not think that would be a possibility or very likely at all in today's this
Well,
important
Dr. Lorian, that is just your opinion, correct?
Counsel. Based on my decade of experience in reviewing local, state, and federal law enforcement agencies, I can say with a degree of certainty that it is incredibly unorthodox for a local law enforcement agency to fully censor all training documents relating to one of its officers. Typically, you would expect to find this documentation even if it had to have an alias on it instead of the real name.
Dr. Lorian, I just want to talk about what's fact in today's case. Now, you said that that information regarding undercover officers can be classified, correct?
Perhaps at the federal level or in international affairs that could be likely, but at local law enforcement, it simply is not likely at all.
Well, you know, Dr. Lorian, let's talk about some of the information that you analyzed. Now, you analyzed emails, correct?
That is correct. I reviewed multiple forms of correspondence between Detective Keenan and the major individuals in today's case.
You reviewed affidavits.
That is also correct.
You reviewed information from defense counsel.
Yes, I did.
And you reviewed information from a public records request.
Yes, Freedom of Information Act specifically.
Now, you would agree that classified information is not included in a public records request.
Public records, if I was denied this information, I would have received notice of it. However, as I have mentioned before, it is highly unorthodox for a local law enforcement agency to fully classify all certification documents. Typically, if these documents exist, you would expect to find them with simply the alias instead of the real name.
Dr. Lorian, you are being paid $10,000 to testify here today, aren't you?
I am not being paid that money to testify. That is incorrect, counsel.
So is it your testimony that you're not being paid $10,000 for your traveling expenses to testify here today?
That is correct. I am being paid for my time away from my company. I am the chief auditor, and we handle 10 to 15 cases per day, which are worth thousands of dollars. This is simply compensation to ensure that I am not running into the red at my business at home while I am working here.
Dr. Lorian, since you're familiar with Officer Keenan's affidavit, you would agree that the first time Officer Keenan met Avery Bancroft was on March the 31st.
I cannot say that with any reasonable degree of certainty, but if you're asking as to the content of Detective Keenan's affidavit, I suppose that is in there, yes?
So, when Officer Keenan met with Ms. Bancroft on March 31st, he brought Corey Hyde with him, didn't he?
According to his affidavit, that is correct, counsel.
And Corey Hyde wore a wire.
As far as I know from the affidavit, yes.
There is a transcript of that meeting.
I am aware of this piece of evidence, yes.
There is documentation of that meeting.
There is.
On direct examination, you told the members of the jury that there was no documentation of Ms. Bancroft's character traits, correct?
That is not correct, counsel.
That's not what you said on direct examination.
I did not make any comment regarding records of the character traits and the personality of Ava Bancroft, no.
Okay, let's move on. On April 13th, Mickey Keenan had a second meeting with Avery Bancroft.
Yes, that is true.
His informant, Corey Hyde, emailed him and told him that there was going to be high security for that meeting.
Yes, that is also the case.
And when they got to that meeting, they were searched.
I believe so.
That meeting was unable to be recorded.
There were no recordings of that meeting to my knowledge.
So what Officer Keenan did is he called a bellhop to the room, correct?
I believe so.
And when that bellhop came to the room, he identified everyone in the room to that bellhop.
That is correct, based on Detective Keenan's own affidavit.
Detective Keenan made a third party aware of everyone that was inside the room, correct?
I cannot testify to the awareness of anybody in this case, but from his affidavit, Detective Keenan did indicate that individuals in that room.
Well, you just said that Officer Keenan identified everyone in the room to the bellhop, right?
Yes, that's correct.
So he made a third party aware of everyone that was in that meeting room, correct?
I suppose.
Now, you looked into the general background of Officer Keenan, didn't you?
I did.
And to be clear for the members of the jury, you didn't find any past history of misconduct on the part of Officer Keenan, correct?
On the part of Officer Keenan, I did not. This was the first and only investigation of Detective.
Objection, Your Honor, improper adherence to evidence. On the part of Detective Keenan.
Okay, response?
Your Honor, I'm not offering character evidence on the part of Officer Keenan. I'm simply asking this witness what he found in his investigation. This witness did look into the general background of Officer Keenan. Now, this witness is simply saying that he didn't find any past misconduct on the part of Officer Keenan in his investigation. This witness has been up here giving his opinion throughout the whole trial. He could definitely testify to this. It's in his personal knowledge.
Okay. What's your response to that, counsel?
Your Honor, may I request a moment to speak?
Sure.
Your Honor, pursuant to Rule 404B, prosecution counsel is attempting to show that because Detective Keenan conducted investigations properly in the past, that's exactly what he was doing again in this case. And that's prohibited, not admissible to prove a person's character evidence as Detective Keenan properly investigating other undercover operations as he might not have in today's case.
Okay, any response to that?
Dr. Lorian, I'm sorry, Your Honor, I'm not using this to prove character evidence of Officer Keenan. I'm just using this to show that Officer Keenan didn't have any misconduct in this case today. Therefore, I'm not using this as character evidence to prove anything in the past.
May I respond on those grounds, Your Honor?
Yes, what's your specific response to the fact that he's not asking about any past misconduct, but any related to this specific case?
Your Honor, the counsel asked Mr. Lorian about Detective Keenan's prior investigations and his background and whether or not he properly investigated in other investigations. He asked him directly about his background as a police officer, so he's trying to use that information and applying it to today's case of saying that Detective Keenan, because he did those investigations properly, investigated properly in today's case.
Okay, so, yeah, I'll sustain the objection to the extent that we're talking about anything outside of this case that we're here about right now. If your question is only about whether Officer Keenan was disciplined for this specific case, that's fine, I'll allow that. But anything from other investigations, I'll sustain the objection.
Thank you, Your Honor. Mr. Lorian, you didn't report any misconduct on the part of Officer Keenan, correct?
That is not the case. In fact, based on all the evidence I reviewed, he violated all of the undercover guidelines, which indicates a great deal of investigative misconduct.
Dr. Lorian, thank you for your testimony. No further questions, Your Honor.
No redirect, Your Honor. I ask that this witness be able to step down.